Welcome back. As predicted, our group has grown. We're certainly happy and want to welcome all of you that have traveled to be here today. We're certainly thankful that you had the time and the opportunity to join us. Before we move into this last segment on Lincoln on Professionalism, I'd like to introduce the new president and CEO at the Robert H. Jackson Center, Jim Johnson. Jim's going to have a few words for us.
Gosh, thank you very much. I just want to take a very, very quick moment and welcome you to the Jackson Center. It's great to have you all here, and the Jackson Center, of course, has had the pleasure of hosting these CLEs for a number of years now, and we very much appreciate the opportunity to host the CLEs, and I'm sure you're all familiar with the things and the programs that the Jackson Center has done and continues to do, and I invite all of you to come and tour the Jackson Center for those of you who have not. Greg insisted that I mention a little bit about who I am and where I came from, but I have just joined the Jackson Center after spending the last 9.5 years as the Chief of Prosecutions with the Special Court for Sierra Leone. Most of that time was down in Africa, in Sierra Leone, but of course the last few years of that time I also spent a lot of time in The Hague, where our court just finished its prosecution of the former president of Liberia, Charles Taylor. And very fortunate with that prosecution, we did secure a conviction of all 11 counts against Charles Taylor, and he will be serving a sentence of 50 years. And thank you very much. That 50 years should very well keep him in jail for the rest of his life, and so we're very pleased with that. I would be happy if any of you want to learn a little bit about war crimes and prosecuting war crimes, and in particular prosecuting a head of state. Charles Taylor was a sitting president when we indicted him, and I would be happy to talk to anybody about that or come and talk about the experience of doing that for a CLE or anything like that if you would like to have that happen. But again, welcome to the Jackson Center. It's great to have you here, and we're proud to host these events. Thank you.
Thank you, Jim. I'm sure you can join all of us. We're happy to have Jim here at the Jackson Center leading the efforts here. We have a very prestigious panel. I'd like to begin introducing them as we begin this segment, as I said before, on Lincoln on Professionalism. First, the Honorable Jeremiah McCarthy. Judge McCarthy was appointed to the United States Magistrate Judge for the Western District of New York in February of 2007. Judge McCarthy practiced civil litigation in Buffalo at the firms of Moot and Sprague and Phillips Lytle. He's a past president of the Bar Association of Erie County and is a former member of the House of Delegates of the New York State Bar Association. Also joining us today is the Honorable Eugene Piggott, Jr. He currently serves as Associate Judge of the New York Court of Appeals. He was appointed to the court by Governor Pataki in 2006, and after practicing law for 8 years, he was appointed Erie County attorney. And in 1997, he was appointed to the New York State Supreme Court by Governor Pataki, and the following year was designated to the Appellate Division, 4th Department. Also, as part of our panel this morning, John Plum. John, having been admitted to the Bar Association in 1970, practiced law in Jamestown until his retirement in 2011. Mr. Plum is a past president of the Jamestown Bar Association, served as a school attorney for 5 districts in Chautauqua County, a former member of the Grievance Committee for the 8th Judicial District, and spent 17 years on the Character and Fitness Committee. Mr. Plum was an adjunct at the School of Business at St. Bonaventure from 2006 through 2011. Also a member of our panel this morning, the Honorable Michael Powers. He serves as a partner at Phillips Lytle in Buffalo, New York. He practices primarily in the areas of commercial litigation, product, and general personal injury defense. served as a confidential law clerk before joining Phillips Lytle in 1984. He was previously served as a member of the Board of Directors of the Bar Association of Erie County and as the chairman of its Judiciary, Appellate Practice, and Justice Court committees. The moderator for our session here this morning will be Gregory Peterson. Mr. Peterson is partner at Phillips Lytle and office leader of the Chautauqua County office. His focus is in all areas of real estate, areas of corporate counseling, including acquisitions, administration, strategic planning, not-for-profit areas, tax exemption, and New York State administrative areas. He is the founder and former president and board chair of the Robert H. Jackson Center. We'll turn this now over to Greg.
Welcome. Just housekeeping matters. How this is going to play out is as follows. We're going to show some vignettes on the screen. There will be panel discussion among this august group. We will look forward to discuss. Listen to that. Because the reason I thought of that, it's funny you should mention it, because Judge McCarthy immediately said, Greg, lead in with Go Irish, and if we could all sing the song. And then John Plum said, Go Irish, and then they went to Mike Powers and John, let's go Bonnies, and I don't know, Judge Piggott, what we're going to do for you, but, you know, the nice thing about this, Judge, I'm off script here a little bit.
Shocker.
Judge Piggott's biography, which is not mentioned, was the fact that in Vietnam, he was an interpreter, and I think that's going to be exceedingly important as we go on for the next almost hour and a half or so, because we look forward to you interpreting some stuff that we otherwise might be very foreign. So thank you, Judge, for all of that. Anyways, back to the schedule. We're going to see movies. There'll be a panel discussion. And then at the end, everybody who wants ethics credit, and I assume there might be a couple, be sure you fill out this form and make sure Mary Parsons received that. After we see the last vignette, I will dismiss everybody. We'll be going downstairs, and there we'll have a wonderful meal, and then I will be doing an interview with J.U. Kalkrick. Now, I just want to pause here because I may not get a chance to talk about it downstairs, but there is so much serendipity and interactivity, and we just was introduced to Jim Johnson, who was our new president, CEO. He was the chief of prosecutions of Charles Taylor. Charles Taylor was the president of Liberia. Charles Taylor was the first president to be indicted, and he was indicted by our chairman of the board, David Crane, when he was the founding prosecutor of the tribunal at Sierra Leone. And then it was Jim's job as chief of prosecutions to make sure that it got into a conviction. Our guest tonight, this afternoon, during the luncheon, is a guy named J.U. Kalkrick. For those from Buffalo area, you may or may not know the name, but he's a real superstar athlete out of Clymer that went to Michigan State, which I think still plays Notre Dame.
Not well.
I want to get that out of the way, too. I mean, J.U. is going to be coming and feeling good about that. Anyways, J.U. is from Liberia. J.U. was there when Charles Taylor was the president of Liberia. J.U.'s father was involved in the political system of which Charles Taylor was a part. J.U.'s dad was assassinated in Sierra Leone. And I don't know the full story. Frankly, I'm most interested to know the full story. And between us, we're going to kind of go through a process here later on where we're going to talk football, we're going to talk his personal life. It's going to tie in ultimately with Jackson, as all things do. And soon, for Buffalo, of course, we're excited about the naming of the courthouse. How far did we get off from this project so far? Lincoln on Professionalism is a CLE seminar based on Abraham Lincoln's life as a lawyer. I think Abe Lincoln is even in the audience someplace today. Produced by the Atlanta Bar Association in partnership with Georgia's Chief Justice's Commission on Professionalism, and using an engaging documentary-style format. Lincoln's exemplary qualities of professionalism as it comes to life, the qualities he demonstrated day in and day out in his law practice. This documentary is coupled with a discussion which we'll be having here shortly, and to discuss current and modern, put into current and modern context, the model of professionalism that Lincoln provides. The resolve to be honest at all events, and if in your own judgment you cannot be an honest lawyer, resolve to be honest without being a lawyer. Never stir up litigation. A worse man can scarcely be found who does this. A moral tone ought to be infused into the profession, which should drive such men out of it. The leading rule for the lawyer, as for the man of every other profession, is diligence. Leave nothing for tomorrow which can be done today. Abraham Lincoln lived by these words and in his law practice. That's just sort of the preamble to a project which we get done after the next almost 2 hours. I think we're all going to be very much better lawyers and professionals as a result of that. So without any further ado, I guess we're going to show vignettes of 1 and 2 and then start the process.
Greg, can these folks see that with us here?
Let me ask, Charlie, can you see it? You good? Okay to see it? Yep.
Abraham Lincoln's law partner of 17 years, William Herndon, believes that Lincoln's lack of vanity, above all else, gave Lincoln his distinctive advantage over others in the profession. He wrote that Lincoln had no disgusting egotism or pompous pride, no aristocracy, no haughtiness, no vanity. As a practicing trial lawyer, Lincoln's lack of personal vanity tempered his response to real or imagined slights and the setbacks that occur during trial, where he remained entirely calm, unexcited, and imperturbable. He avoided insult to his opponents, and he had never made the trial of a case a personal issue between counsel. In the courtroom, Lincoln projected that sense of goodwill necessary to gain a jury's respect and create the atmosphere required for success. Lincoln's lack of vanity sharpened his interest in other people over himself and led to both his keen insight into human nature and his compassion for the human condition, qualities that also helped to explain his successes in the courtroom. He instinctively understood the values and motivations of witnesses, opponents, and jurors. He knew whether they could be trusted. He also saw the heroic qualities in his clients and could translate their fears and dreams into irresistible pictures for the jury. In Lincoln's closing argument in a case he successfully tried for the defrauded widow of a Revolutionary War veteran, he said,
"Time rolls by, and the heroes of '76 have passed away. The soldier is gone to rest. And now, crippled, blind, and broken, his widow comes to you and to me, gentlemen of the jury, to right her wrongs. She was not always thus. She was once a beautiful young woman. Her step was elastic, her face fair, and her voice as sweet as air that rang on the mountains of old Virginia. But now, she is poor and defenseless. Out here on the prairies of Illinois, many hundreds of miles from the scenes of her childhood, she appeals to us who enjoy the privileges achieved for us by the patriots of the Revolution for our sympathetic aid and manly protection. All I ask is, shall we befriend her?
Lincoln also presided over hundreds of trials in Illinois' 8th Circuit when Judge Davis could not. As a judge, Lincoln was infinitely kind and considerate. Since he had no irresistible passion for authority, Lincoln could deftly Those who mistook his friendly personality for weakness soon woke up on their backs in a ditch. He was merciless against anyone who mistreated his clients. This kindly man, said early biographer Henry Benz, could be the worst of enemies, whether to an unjust judge, a dishonest lawyer, or anyone else who tried to take unfair advantage of his clients or friends.
Mr. Lincoln, as you are an attorney of great repute in this state, I was hoping to bend your ear before my trial tomorrow.
Of course, my good man. Dispensing advice to a smart young attorney such as yourself is a great privilege. What is your question?
Well, my client insists that the plaintiff's suit is barred by the statute of limitations and wants me to get the court to dismiss the plaintiff's case. Technically, my client has an argument, but unfortunately, a fair reading of the case law just doesn't support my client's position. What should I do, sir?
In your few years of law practice, you've established a reputation as a lawyer of integrity and honesty. Such a reputation enables you to be a better advocate for your clients. The court is much more likely to side with an attorney it knows will state the law accurately and fairly. Can you, in good faith, distinguish your case?
I think I can construe the law, sir, in a manner that is more favorable to my client's position if I direct the court to a specific factual element in my case. But, in all candor, Mr. Lincoln, logically, I don't believe that the distinction makes much of a difference in light of prior authority.
I've found in my practice that it's important not only to be morally honest, but intellectually honest also. If the reasoning behind your argument is flawed, your argument will likely fail and could damage your credibility with the court. Those times in which I made arguments that were logically flawed, I was the weakest, most ineffectual lawyer in the state.
I understand your point, but isn't a lawyer's role to be a zealous advocate, to construe the law in a manner most favorable to your client?
As an officer of the court, you must provide a fair interpretation of the law, then advocate why the facts are in your client's favor. It'll serve your client little purpose to twist the law or to make arguments that are not logically sound. I've found that such arguments not only fail, but, well, also damage my ability to zealously argue the strong points of my case.
So, if I understand you correctly then, you believe that raising the statute of limitations argument could hinder my ability to advocate on behalf of my client.
You learn fast, my good man. If you have, under a fair interpretation of the law, a reasonable likelihood of prevailing on your statute of limitations defense, then by all means raise it. Otherwise, inform your client that his ends would best be served by asserting more persuasive defenses. Now remember, in the law, it is generally good policy never to argue what you need not, lest you oblige yourself to prove what you cannot.
To attorneys, especially young attorneys who, fresh from law school, have all this base knowledge, and they want to display that base knowledge. How do you help them prioritize that? Mike?
A couple of comments, Greg. First of all, on the vanity piece, one thing I try to convey to our associates is that the case is not about the attorney, and that is, it's an obvious truth, but too often lost in the fog of battle. The matter is about your client and your client's cause, and anytime you allow your own vanity or personality to get involved, and granted sometimes it's hard not to do that, You've done your client a disservice, and I think most judges will pick that up, and it will hurt your cause. On the, the overall candor with the court, because we only have 7 minutes in between, I'm going to defer to everyone else, but I can tell you that when I'm on the bench, I generally know what the facts and the law are, but I want to hear the attorneys, but I do not want to hear spin or meritless arguments, because as Lincoln said, it not only hurts your cause because it's going to fail anyway, but it's going to adversely affect your ability to represent your client through the rest of that case.
Judge Piggott?
I couldn't help but think while we're watching this is probably the wrong place to have this discussion. In my experience as the presiding justice of the appellate division, we did what we called have gavel will travel, and we went to 16 of the 22 counties in the 4th Department, which goes about as far east as Utica. But the lawyers in the outlying counties know what Lincoln says better than anybody in the cities. And when I was here, when I was in every one of these, you have a bench and bar that know each other. You have a bench and bar that get along. You realize that much of what Lincoln says, it comes back to bite you. I mean, if you want to be a jerk about stuff, you can do it very easily, and you're going to do it alone. The interesting thing about dealing with the court is magically it seems that the courts seem, I can't make a mistake. I'm not, somehow you've got to cater to me. You do to some extent, because of course we get to make the decision. But the reason they talk about honesty in this, I think, is that when I look at a brief, there's one that I've kept where the lawyer teed up the argument. Let's talk about like the statute of limitations argument there. Would tee that up saying the statute of limitations is an issue in this case. If looked at this way, it's this way. If it's looked at that way, it's that way. I believe it should go this way. And it was a much more complicated issue. But by the time I got done reading it, I realized that a lawyer here was being so honest and teeing it up for me, because I didn't know what he was talking about. And it made sense. And I thought the honesty that we talk about is not lying. The honesty that I think you can take away from this is things like that. Just teeing stuff up the way they should be, speaking in the appellate sense, or even in your motions. And as you all know, your reputation gets made very, very fast. And so doing things like that and just not letting your client drive your reputation into a ditch can be very helpful.
Judge McCarthy?
Well, I'd like to just correct or clarify one point that Judge Piggott just made. In federal court, we do expect you to cater to us. But the point on vanity, and I'm probably preaching to the choir, speaking to a Western New York audience, but because as the judge said, what goes around comes around, everybody knows that, and whether you're dealing with a litigated matter or with a commercial deal or real estate deal or whatever, you know that the person that you're dealing with, you're likely going to come into contact with again, and I think that's a good self-policing mechanism. We are all human beings. We can all make mistakes. From my vantage point, people object all the time to my decisions, and many times they object with good cause. All I can do for my part is to do the best I can, try to get it right, and if somebody agrees with me, fine, and if they don't, well, then we'll let somebody else sort it out. On the issue of which arguments should be made, one thing I find interesting is when I look at a defendant's answer and I look at the in many cases, a laundry list of affirmative defenses that they've pled, 3/4 of which have nothing to do with the case, and 3/4 of which probably in most cases won't even come to the court's attention. But I think that's just an indication in some instances of a word processor gone wild, and, well, we got it here, it's on our form, let's throw it in. It's always more impressive to me if an attorney will do the hard thinking and really focus on what his or her strong arguments are. And that's a gutsy call sometimes because you don't want to give everything up. But you got to realize that not every argument is a winner. And if you push every argument conceivably that you have, you run the risk of diverting the judge's attention from the argument that may be a winner. So you really got to separate the wheat from the chaff.
John?
Just a couple of things jump out at me. Having practiced down in Chautauqua, Cattaraugus County, done a lot of litigation work, not only be candid to the court, be candid to the jury. Don't let the jury think you're trying to pull a fast one over them. It just doesn't work. You want them to trust you. Another thing that jumps out at me at this point, Lincoln, not a lot of formal education, mostly taught himself, struggled. He's talking about things in this video we're looking at that has now been codified in the New York Code of Professional Responsibility. Just talking about being candid with the court, you have an obligation under those rules, I think 3.1, 3.3, to be straightforward with the court as to what the law is, unless you can legitimately come up with some form of modification or extension or even a reason to reverse a prior court. And so when you're approaching a court, maybe especially an appellate court, bring that out. Be blunt. I remember one of my last appearances before the appellate division, I think one of these judges was sitting there. I'm not going to say which one, but I brought it out. I was trying to bring out an extension of the law. It had to do with animal rights or something like that. And I tried to level with the court as to what my position was. And I remember one of the judges on the appellate division, who happens to be here right now, saying, Mr. Plum, we appreciate your position. You can sit down now. I kind of knew what that meant, and subsequent opinion bore that out. That's all I have to say.
Let's watch the next one.
I didn't know this was a roast.
For Abraham Lincoln, honesty was fundamental to his law practice. He practiced law from 1837 until 1860, and much of that time was spent on the circuit. He tried hundreds of cases before the 8th Judicial District in Illinois. Twice a year, Lincoln traveled the circuit, which was the size of Connecticut, a 400-mile trek on horseback that took nearly 3 months to complete. On the circuit, Lincoln was known as Old Abe, or Honest Old Abe. He had an unusually high reputation for ethical practice. Around 1850, he gave a lecture on the law that addressed the popular belief that lawyers were dishonest. He warned,
Let no young man, choosing the law for a calling, for a moment, yield to this popular belief. Resolve to be honest at all events. And if, in your own judgment, you cannot be an honest lawyer, resolve to be honest without being a lawyer. Choose some other occupation.
Lincoln's concern for honor and honesty bore directly on the outcome of the 1847 case styled Case versus Snow Brothers. Lincoln represented the plaintiff, Old Man Case. The Snow Brothers had purchased a team of oxen and a plow from Mr. Case, and being without funds to pay him, had given him a promissory note. At the time of the purchase and execution of the note, the brothers were not of majority age. Mr. Case knew this, but nevertheless accepted the note. When Mr. Case went to collect on the note, the brothers refused to pay on the technical ground that they were not of age when they signed the note. Mr. Case retained Lincoln to help him. Lincoln was confronted with an obstacle in recovering on the note, the fact that the note was executed when the brothers were legally minors. This was known as the defense of infancy. Faced with this technical defense, Lincoln sought a way around it. He conceded that the defense of infancy was proper in valid instances where there was overreaching on the part of the person who was of majority age in executing the contract. But rather than focus only on his client's desire to get repaid, Lincoln argued about what was in the best interest of the boys, the defendants. To do this, he turned his argument to their character. As recounted by George Minier, a witness in the case who was one of the first settlers in Tazewell, this is what Lincoln said to the jury.
Gentlemen of the jury, are you willing to allow these boys to begin life with this shame and disgrace attached to their character? If you are, I am not. The best judge of human character that ever wrote has left these immortal words for all of us to ponder. Good name in man and woman, dear my Lord, is the immediate jewel of their souls. Who steals my purse steals trash. 'Tis something, nothing, 'twas mine, 'tis his, has been slave to thousands. But he that filches from me my good name robs me of that which not enriches him and makes me poor indeed.
The jury returned a verdict for Lincoln's client in the amount requested.
This is a case where if you have good law and bad facts, you pound the law. If you have bad law and good facts, you pound the facts. And if you have neither good law nor facts, you pound the table. Is that what that was? John, I'll let you, because you certainly left everybody on a high note when you last talked.
The only thing I would add to this is that the more you read about Lincoln, is that he struggled constantly with trying to do the right thing. Never had any formal courses in ethics, for example. And where he came up with these insights, it's hard to tell, but he was constantly trying to do the right thing, and he would struggle with whether or not it would be appropriate to hammer away at the facts or the law in a given circumstance. And it almost became a moral dilemma for him each and every time. He was a very, very complex person. Those are my initial thoughts.
Judge McCarthy, did you see a lot of just pragmatism, and where does that fit into the ethics and practice of law?
I'm not going to answer that question, Greg. If I may, and maybe this is really off script, but what I was struck about that vignette is how did this even get to a jury? Because that would be a defense that many people might think is not a good defense, is not a moral defense, but it was a defense in law of infancy. So I guess my question is, how was Lincoln even able to argue to a jury? Now, having argued to the jury, he obviously did a great job, but that just raises the point in my mind, both as judges and as lawyers, we're committed to uphold the law whether we agree with it or not, and we always tell jurors that as well, that regardless of whether or not they believe that a particular law is good or bad, wise or unwise, just or unjust, their obligation is to uphold it. And again, I just don't know how he got to argue that to the jury.
Lack of a knowledge of the judge.
Well, it could be. You know, he wasn't in federal court. That's what.
All right, Judge Piggott.
I have a theory I always call the blue jay theory. The blue jay never builds a nest that steals somebody else's. And I did that all my practice. I always thought that if it was a cover letter, if it was a motion, if it was a settlement letter, if somebody writes it and it's really good, I would steal it. I would give it to my secretary. Say, this is what our cover letter is going to look like. This is what our enclosure letters. I did it with pleadings. I did it with almost anything I could find, because there are so many outstanding lawyers out there, and there's no sense in reinventing the wheel each time. So when Lincoln talks about, as Jerry points out, trying to get a case to a jury that may not get there, I suspect some of it is because in the early part they talked about his reputation for honesty and a judge allowing it. I remember I used to do Sunrise Court when I was a young lawyer, and it was the Saturdays and Sundays in Buffalo when they would try to get the people who got arrested overnight out on bail, et cetera. And one of them had a private lawyer who came in, and this was a very prominent lawyer, probably one of the leading lawyers in Buffalo. We're in city court on a Saturday morning. And he had come over from Canada, where his home was, his summer home. And the first thing he did is he apologized to the court for not having a tie. And I can remember it to this day. I thought, here is I mean, you're talking to a judge who, was probably maybe 10 years out of law school. You're in the middle of this chaos of mostly DWIs and petty thieves who were just trying to get through. And the respect he showed for the court did not surprise me once I heard it, because that's why this lawyer is so well respected and gets as far as he does on so many of his cases. And I think once again, it's your core. It's what you're made of, what you think of, and what you think of the law. And I think that's all Lincoln was saying in this particular case.
I had a number of cases with Judge Piggott when he was a practicing lawyer. I don't recall him ever copying anything that I wrote. What struck me about that vignette really were two things. One, Lincoln's creativity. It also struck me the same as Judge McCarthy. How did this thing ever get past a dismissal on the basis of a question of pure law? Perhaps it wasn't a question of law at the time, and that's how he got to the jury. But the creativity that he used to turn this around and speak as if he were defending the honor of the people who were actually proceeding against his client, I thought was absolutely brilliant. And I think the lesson in that is that Lincoln, and you'll see this throughout these vignettes, always appealed to the best in people, whether it was a judge or a jury, and he was remarkably effective in doing that. And it's something I think we can all remember when we're making our arguments to the court or to a jury, that if we appeal to what's best in all of us, you're gonna create an affinity with the people who are listening to you and who are going to decide your case.
We're going to show part 4, Candor to Opposing Counsel.
A lawyer in Beardstown related this. Lincoln came into my office one day with a remark.
I see you've been suing some of my clients, and I've come down to see about it.
He had referenced to a suit I had brought to enforce the specific performance of a contract. I explained the case to him and showed my proofs. He seemed surprised that I should deal so frankly with him, and said he would be as frank with me. So my client got a deed for a farm which, had another lawyer been in Mr. Lincoln's place, would have been consumed by the cost of litigation for years, with the result probably the same in the end. If in debate with Lincoln, a man stood on a questionable foundation, he might well watch whereon he stood. Lincoln could look a long distance ahead and calculate the triumph of right. With him, justice and truth were paramount. If to him a thing seemed untrue, he could not in his nature simulate truth. He once wrote to one of our clients,
I do not think there is the least use of doing anything more with your lawsuit. I not only do not think you are sure to gain it, but I do think you are sure to lose it. Therefore, the sooner it ends, the better.
once I drew up a fictitious plea so as to work the desired continuance of the case. This was done in the absence and without the knowledge of Lincoln. Lincoln came into court. He looked carefully over all the papers in the case, as was his custom. I could see at once it failed to strike him as just right. He scratched his head thoughtfully and asked,
Hadn't we better withdraw that plea? You know it's a sham. And a sham is very often but another name for a lie. Don't let it go on record. The cursed thing may come staring us in the face long after this suit has been forgotten.
The plea was withdrawn. I only relate this incident to illustrate Lincoln's far-seeing capacity. It serves to show how overcautious he seemed to be with regard to how his record might look in the future.
Sometimes
Candor to opposing counsel, dealing with the issue of pragmatism versus kind of expressing your long knowledge in the law. How do you balance those acts? And Judge McCarthy, why don't you start us on that?
Well, and it's been said several times already, and probably will be mentioned several times again, but the most valuable tool that you have, both as a lawyer and as a human being, is your reputation for integrity, and it takes a long time to develop and a very short time to destroy. I think not only because it's required in the law, but just because it's the right thing to do, you need to strive to develop the reputation with all that your word is your bond. I pulled the civility principles of the Western District, and they're very similar to the principles in state court, and they're really the type of thing that shouldn't even need to be written down, but it doesn't hurt to remind ourselves. By way of example, it says, we will in good faith adhere to all express promises and to agreements with other counsel, whether oral or in writing, and to all agreements implied by the circumstances or local customs. When we reach an oral understanding on a proposed agreement and decide to commit it to writing, we will endeavor in good faith to state the oral understanding accurately and completely. We will not include in a draft matters as to which there has been no agreement without expressly advising other counsel in writing. It's a very sad thing when, and I know it happens, and it happened in my practice once in a while, where you finally say with your opponent, I'm not going to communicate with you anymore orally, we'll do everything in writing because I just can't trust your word. And I hope I was never the source of that. On a rare occasion, I felt that I had to do that. Fortunately, not very often, but you really need to develop that reputation that people can trust you. And if there is a misunderstanding, a good faith misunderstanding, you got to be open to the possibility that perhaps you got it wrong. I don't know if that answers your question, but that's what I wanted to say.
John?
Just a couple of comments. As Greg knows, I taught a business ethics course down at St. Bonnet's, and one of the philosophical individuals that we would talk about would be Adam Smith, an economist, a philosopher, somewhat of a egotistic approach to things, but he would always say that in business, your word is very important. And if word gets out that you can't be trusted, you may make some financial gain for a short period of time, but it's going to come back to haunt you. And so be it with the practice of law. If word gets out, especially in a small rural community, that you can't be trusted, that's going to be a problem you're going to have to live with for a long, long time. So candor and honesty with opposing counsel is extremely important. You've got to be able to be trusted, and you have to have trust in the attorneys you're dealing with.
Mike?
I think we're blessed in Western New York to not have to deal with this issue as often as lawyers have to deal with it in other places, but as Judge McCarthy said, unfortunately there are times where we do. I have found that young lawyers are sometimes more aggressive. I know I was. Sometimes pushing the envelope a little further than perhaps lawyers with a little more gray hair. And I think it's important for all of us, especially those who have a few years on us to point this out to young lawyers. I think you can do a great service to the bar, and I'm going to tell you a very quick story. I had a matter with a young lawyer about 10 years ago, and his affidavit on a motion for summary judgment accused me and my client and virtually everyone else of fraud and misrepresentations and some of the usual nonsense. I called him up and I said, why don't we meet in court about 15 minutes before we're scheduled to argue? And I sat down with him and I pointed this stuff out. I said, do you really mean that? And he was quiet for a minute. He goes, well, not really, but... And we talked it out, and I said, as happened in the vignette, I said, you might want to mention to the court that you're clarifying a couple of those issues. And to his credit, he did that. I was very pleased to see that and frankly quite proud of him. And we've been friends ever since, and he brings that up once in a while. And it just was a matter of tempering his enthusiasm a little bit, which is a little different than the pathological liar who usually doesn't last very long in the practice of law. And to add to what Judge McCarthy said, for all of those reasons, it's a bad thing to do, in addition to the fact that you're not going to get away with it. Lawyers are all pretty smart people, and you're not going to fool your opponent, you're not going to fool the judge. So it's a fool's errand to begin with, and you risk doing irreparable damage, not only to your own reputation, but to your client's cause.
Judge Pickett?
Well, we're all trying to get through this veil of tears together, it seems to me, and the practice of law is not easy. And I always, once I got on the bench, and I've been on the bench now for 15 years, there's two levels of lawyers. There are those that are good, and their goal is to get this case done. And when you got two of them together, the problems go away. Things just get solved, and the case moves, and things turn out the way they should. You got the other ones, as my fellow panelists have talked about, that just look for ways to put a stone in your shoe, to put something in your way. I don't know how to handle them. It's very, very difficult. I look at it from the judiciary side, as I think the judiciary's got a problem. And the problem is that when I look at the number of mediations and arbitrations going on now, every single one of them to me says the courts are not doing their job. And I don't think we are. And I think the toll booth justice that we've got going these days, and the incredible obstacles in terms of depositions, and how many, I know there's a good number of trial lawyers here, how many times have you gone to trial, finished the trial, and every single one of those EBTs never left the red well? They were all done defensively, they're all done because they have to be done. And I think our justice system is just grinding so much. And when two of my former colleagues, Judge Green and Judge Gorski, told me they were joining a mediation service, I told Judge Gorski, I said, you know, if you were around when I started, I said, before I even sued a case, I'd come over and see you. I mean, obviously you got to sue the case in order to get it on the docket, but sooner rather than later, because there's just so much nonsense going on. The good lawyers can handle it. The ones that can't are just clogging up the system, and it's a real problem. And once again, it's a problem that I find more common in Onondaga, Monroe, and Erie counties, and not in the rest of the counties that make up the Fourth Department.
Greg, could I just add one point?
Sure. You got to check with Mary to make sure that's okay.
Mary, is that?
Okay, good.
And then I'll say less next time, I promise. One other point I wanted to touch on from the vignette, and that is, and I speak, I think, particularly to young attorneys here, a very gutsy thing to do is to tell your client that a particular argument is not a good one and shouldn't be made. And that's really where the rubber meets the road, because there's a lot of pressures, I know, revenue-wise and productivity-wise, but you've always got to bear in mind that you have an obligation to the court and to opposing counsel only to make arguments that you feel you can make in good faith. And on the outer perimeters of that, of course, in federal court you have Rule 11, and in state court you have comparable provisions where you can really get yourself in hot water for making an objectively unreasonable argument. But even if it's got some attractiveness to it, take a hard look at all the arguments you're making, and if you need the assistance of somebody more senior to go to the client and say, look, we really got to back off on this, I think you should do so.
Our next one is Part 5, Dignity and Civility.
Sometime in the fire, sometime in the fire.
When Abraham Lincoln died on April 15, 1865, his Secretary of War, Edwin Stanton, could not control his grief. At the mention of Mr. Lincoln's name, he would break down and weep bitterly. Lincoln's death ended a remarkable personal relationship between the two men, which was all the more remarkable for how it began. 10 years earlier, in June of 1855, the John Manny Company of Rockford, Illinois, faced a charge of patent infringement in Chicago, brought by Cyrus McCormick, the original inventor of the crop reaper. The company hired Lincoln as local counsel. Both parties were represented by the most preeminent and experienced lawyers in the country. Lincoln thought the case an opportunity to test himself against these great lawyers. Unknown to Lincoln, though, he'd been retained merely as window dressing because of his experience with the trial judge. Lincoln was paid a retainer, but the lawyers who involved him knew Lincoln would have no real role. Without disabusing Lincoln of his presumed role in the case, their ultimate plan was to sidetrack him when the time came to do so. The notoriety of the case caused it to be reassigned for trial to a justice of the Supreme Court, and venue was moved to Cincinnati. This gave the Manny Company lawyers the opportunity to hire the person they had wanted all along, Edwin Stanton, a brilliant and well-known lawyer of the day. Lincoln remained in the dark that his role had gone from minuscule to none. A month came and went, and by late July, Lincoln had not received requested materials on the case, despite several inquiries. Ever industrious, however, Lincoln traveled to Chicago for a copy of the court file he never received, and even visited the Manny Company to inspect the machine. As far as Lincoln knew, he had a trial brief to prepare. By late September, Lincoln still had heard nothing from the client or the lawyers that retained him, but he finished his brief and set off for Cincinnati. The plan to sidetrack Lincoln was presumably going to be subtly, if not professionally, handled, but it played out otherwise due to the brusque and disdainful personality of Edwin Stanton. Lincoln arrived at the hotel hosting the Manny Company legal team, introduced himself, and offered, "Let's go up in a gang." Responding to Lincoln's invitation, Stanton whispered to the others that they should let that fellow go with his own gang, and announced that he and another lawyer were instead walking together. Lincoln was left to make his own way to the courthouse. Stanton went on, asking his companion why he'd brought that damned long-armed ape here, and concluding that he does not know anything and could do you no good. Stanton later made plain to Lincoln that he should remove himself from the case, and Lincoln graciously withdrew. The brief Lincoln had prepared was never opened, the lawyers being so sure that it would be only trash. Lincoln nevertheless remained in Cincinnati and watched the trial. Each night he returned to the same hotel as the other lawyers, but was never asked to join them. He ate alone instead. They did not so much as invite Lincoln to walk with them to and from court each day. It was once said of Stanton that politeness was not one of his weaknesses. Stanton's disparaging comments about the early Lincoln presidency became well known in Washington circles, with Stanton referring to Lincoln as an imbecile. 5 years after his painful visit to Cincinnati, Lincoln, the president, was in need of a new Secretary of War. His choice was none other than Edwin Stanton. Stanton had humiliated, snubbed, and marginalized Lincoln at the Reaper trial, and later criticized his abilities as president. But what Lincoln considered was Stanton's powerful reasoning, his passion, and his unparalleled energy. These were the qualities Lincoln needed in the War Department, and his personal mistreatment at the hands of Stanton was an irrelevance. The singular issue was what the fragile Union needed, and as far as Lincoln was concerned, what it needed was Stanton, regardless of Stanton's known and quite negative personal feelings for Lincoln. The secretiveness which Lincoln wholly lacked, Stanton had in marked degree. The charity which Stanton could not feel coursed from every pore in Lincoln. Lincoln was as calm and unruffled as the summer sea in moments of the gravest peril. Stanton embodied sternness, Lincoln good nature. Together they made a remarkable team and worked tirelessly to save the Union. The lawyer who originally retained Lincoln in the Reaper trial complimented Stanton many years later about some remarkable passages he'd read in one of Lincoln's public statements, assuming that Stanton, rather than Lincoln, must have been the author. Stanton quickly set the lawyer straight. Lincoln wrote it, every word of it, and he is capable of more than that. No men were ever so deceived as we were at Cincinnati. Lincoln's relentless abilities to forget and forgive, to look beyond the slight, the unprofessionalism, and the ego of a self-appointed superior, and to take the high road when human nature might suggest a response in kind, are each an example and model to all lawyers to steadfastly maintain civility, even in the face of incivility.
Part of that vignette clearly dealing with dignity, civility, and also humility has a couple of quotes which jump out. It's in your booklet. "Humility makes great men twice honorable," said Benjamin Franklin. "A man wrapped up in himself makes a very small bundle," another Benjamin Franklin. However, then there's Mark Twain, who said, "Always acknowledge a fault. This will throw those in authority off their guard and give you an opportunity to commit more." And as Golda Meir once said, "Don't be humble. You're not that great." Being able to watch that particular vignette and where Abraham Lincoln showed so much constraint, how difficult is that in the real world, Mike?
That vignette and that story about the McCormick case is one of my favorites about Lincoln. And every time I hear it, see it, it just strikes me how incredibly extraordinary that man was. If you stop and think about what happened to him and what they did to him in Cincinnati, and then when it came time to appoint his cabinet, knowing what faced him in 1861, and he chooses Stanton as a Secretary of War, I would like to think that I could be that big a person. I'm not sure I could. But I think the message in that is that this is what we should strive to be. If we could even come close, I think we would have accomplished a lot. And that applies in our practice and in our personal lives. And if you haven't read the book, I'm going to get the title wrong, but I think it was A Gang of Rivals or whatever, Dorothy Kearns Goodwin. Team of Rivals. Read it, because they talk, it wasn't just Stanton that he appointed to his cabinet. He appointed other people who were his political opponents, but he did it, to hearken back to what I mentioned about the first vignette, because he knew it wasn't about him. It was about the cause, or in legal practice, about your client's cause, and he always looked to do what was best for the cause and his clients, and in this case, the country, regardless of his own personal feelings.
Judge Pickett?
I don't. I really appreciate that. That's really nice, and it's great when you have two people involved in a lawsuit that are talking only about money. I think the difficulty in the practice, particularly, I did mostly personal injury work, but also in family law and matrimonial law, is it's great to think that way, but I just don't. And you may have 100 cases, your client has one. And they will think about you, they will take their kids out of school, they will cancel vacations, they will get up in the morning and wonder what you're doing about their case. And of course you're not. You're working on some other case and doing whatever has to be done. But when the time comes, you're that person's advocate and you're that person's mouthpiece in court. And I just think that if I was second chairing, 'cause I've never second chaired a case, but if I was ever in a situation where my client needed my help and because somebody else was elbowing me out, I doubt that I could remain silent. So I give Abraham Lincoln a lot of credit, and I think he's going to do well in his career. The other side of that, though, is almost as important, because your client has one, you have 100, but you've got to balance these things. And when you get some crazy client, and believe me, if you haven't gotten one yet, you haven't practiced long enough, and you got to tell them, and you've got to let them know that you control the case. There's a vignette in here about someone saying, I want to give you the adjournment, but my client won't consent, and then they do anyway. Well, that's the way it's supposed to be. Your client can run the case to some extent, but they don't know the law, they don't know the process, and they don't know how important it is for lawyers to act like lawyers and get things done. So while I appreciate the fact that Lincoln was able to remain silent, that just doesn't resonate with me. I don't know how you do it. And I just think you have to try to strike that balance between representing your client to the best of your ability and remaining as professional as you can be.
Striking that balance between professionalism and sort of that civility, Judge McCarthy handed out to everybody, and I'd be anxious if you want to comment on a case which he has, Kenneth Billett versus City of Buffalo. Is this the time to drop this one in?
Sure. Sorry, Mike. Well, it was said earlier today, and it's true, no matter what field you're in, law, anything else, it's not about us, and we've all got to try to remind ourselves of that. Sometimes that's easier than others to keep in mind, but I've had the experience in 5 years on the bench, the gamut of things that have been said to my face. I have no idea what's said behind my back, probably that's just as well, but I had a defendant refer to me 3 times during an arraignment. I was instructing him that he had the right to remain silent and so forth, and he said, "Yes, my lord." And I went on. I thought, I probably didn't hear him right, and I talked about an attorney. "Yes, my lord." And I said, "Sir, I appreciate the respect, but you can just call me judge." And he said, "Yes, my lord." So I went home, and I announced to my wife that there was a new regime. And you can all, any of you who know my wife, you can all guess where that went. On the other end of the spectrum.
I have to interrupt.
Yeah.
You know, this brings up that joke about the difference between a federal court judge and God.
Those are district judges.
God doesn't think he's a federal court judge.
Sorry. That's quite all right.
I'm retired, I can say that.
On the other end of the spectrum is the case that I had handed out, and it was a pro se plaintiff, and just to give you an indication of the type of things that can be said, this gentleman wanted me to recuse myself several times, and each time I refused, but my personal favorite was his motion that said, and I quote, "Judge McCarthy believes that he is God Almighty. I have a right to a sane judge. I demand one. Let Judge McCarthy go someplace, get some treatment, perhaps shock treatment, Thorazine, and maybe he will get well." Now, I know that many of the partners at Phillips Lytle, but I didn't dismiss the case at that point. I vented a little bit to my law clerk, but I thought, what he's trying to do is goad me into getting exactly what he wants, which is another judge. And so I wrote what I thought was a very calm decision, and I said, if you disagree with my rulings, you're free to take an appeal, but this cannot continue. Well, if you read in the opinion later on, we had another little set to, and he asked me, who the hell do you think you are? And then I told him if he didn't stop, I would dismiss the case, and he said, oh yeah, and he hung up. So that was the end of the case, and I am, as I said to John earlier today, I am still waiting to be named as a defendant, and I'm sure that will be coming. But we all, you know, we're all going to hear a lot about ourselves over the course of our careers, some good, some bad, and you've got to just take it all with a grain of salt, I guess.
I would like to just make sure there's no misunderstanding. When you read that decision, all those things that guy called Judge McCarthy, very few of them are true.
And Mike will tell you which are.
Mike, a partner of Phillips Lytle, thanks. John, you also have an experience with the same person. Do you want to comment on this?
No. No. I was involved with litigation representing the county of Chautauqua, and it would appear that it's a similar plaintiff. But otherwise, no, I'm not commenting any further.
Greg, very quickly, I'm involved and have been for about 10 years in a matter where almost identical things were said about my client, about me, about many others. I don't know if the lawyer who's working on that case is out there or not, but it's a rather infamous case in our firm, and I have had the opportunity to suggest to a number of young lawyers that when you read these things, as personal as they are, you can't take them personally. And if you read Judge McCarthy's opinion, you can see that's exactly the way he handled it, with great dignity and skill, by diffusing the personal aspect of what was being done and just sticking to the facts and the law. And I think if you do that in your practice, your clients will be well served, and frankly, you'll sleep a lot better at night too, because it never helps to lower yourself to the lowest common denominator, if anyone were even able to do it in one of these cases.
We're on to part 6 now, courtesy and goodwill.
As a lawyer and a politician, Abraham Lincoln consistently exemplified the attribute of civility. His civility of manner was the outer manifestation of what might better be called magnanimity. In his attitude and behavior toward his adversaries, he was never vindictive. His humility and generosity of spirit were noted by all who remembered him. In his greatest and final speech, the second inaugural, Lincoln emphatically refused to cast the Civil War as a contest between good and evil, and he steadfastly resisted the urge to be celebratory. Notwithstanding that the long nightmare of the Civil War was nearly over, with Union victory plainly in sight, the speech has no hint of triumphalism or boasting of Union superiority.
The prayers of both could not be answered. That of neither has been answered fully. The Almighty has his own purposes. He gives to both North and South this terrible war as the woe due to those by whom the offense came.
While Lincoln condemned the institution of slavery, he admonished the victorious Union side that this was not Southern slavery, but rather American slavery. Both North and South owned the offense.
It may seem strange that any men should dare ask a just God's assistance in wringing their bread from the sweat of other men's faces. But let us judge not, that we be not judged.
The famous concluding words of the speech best reveal his attitude toward adversaries.
With malice toward none, with charity for all.
Malice, the deliberate intent to harm someone, had no place in Lincoln's makeup. and charity echoes Paul's letter to the Corinthians, meaning an unselfish love that seeks the well-being of others. Lincoln was no moral relativist. He knew that slavery was evil, and he was resolute in waging the bloody war that brought slavery to an end.
With firmness in the right, as God gives us to see the right, let us strive on to finish the work we are in.
He showed, however, that one could be resolute, tenacious, undaunted, and persistent without being self-righteous, simplistic, or absolutist. In the heat of litigation, lawyers sometimes view the adversary as the enemy who must be vanquished at all costs. The result is often shrill, unproductive conflict, which creates hostility, alienation, and distrust. Many lawyers claim that they would much prefer to litigate in a more cooperative and collaborative manner, but that the tactics of their adversaries force them to respond in kind. The key to escaping this spiral of retaliation is to see, with Lincoln, that our adversaries are not enemies that must be vanquished. They may be taking actions that must be resisted, but that does not mean that they are evil persons who must be destroyed. Instead, even in conflict, we recognize what we have in common is more important than what separates us.
To bind up the nation's wounds, to care for him who shall have borne the battle, and for his widow and his orphan, to do all which may achieve and cherish a just and lasting peace among ourselves and with all nations.
With malice towards none. How do you put that into practice? John?
I think it's a matter of, especially between counsel, a matter of courtesy. I thought this over a lot. I think that in the rural communities such as Chautauqua, Cattaraugus County, I think that we all get along pretty well. I think there's a lot of mutual respect. I think as compared to society as a whole today, whether you're talking talk radio or cable TV or unfortunately politics the past few years, lawyers as professionals are attempting to do their best. The very fact that there are so many of you here today, the very fact that we're required to take these courses on ethics, the very fact that you open any local brochure and see who's on the not-for-profit boards and who's the contributors for the United Way or the Red Cross or what have you in town, lawyers' names will keep popping up. It's extremely important to continue that part of our profession, as hard as it is today, the business side of it. But I think we're all doing pretty good down here. That's my observation. I've got to go back to the other video real quick. It was Stanton, I believe, who said, Doris Kearns Goodwin's book, Team of Rivals, that he belongs to the ages now, after he passed away.
Judge McCarthy?
I think we're, and I agree with John, and I think it's also true in Buffalo that we don't normally have the problem of real vindictiveness among attorneys, with a few exceptions. But you know, believe me, I've been on the bench for five and a half years, and we have our own set of pressures. But I have not forgotten and never will forget the pressures that the private bar operates under, keeping the lights on, trying to balance your work life, your family life, and trying to be a decent human being to boot. And I don't think anybody, I hope nobody misunderstands from what we've all been saying that we expect everything to be kumbaya all the time. In the litigated sphere, for example, I mean, you got parties with different viewpoints, otherwise you wouldn't have a case. So you do have to advance those viewpoints, and many times vigorously, and many times you may get angry in the process. That's all I was going to say part of the game, but it's not a game, but that's part of the process. But I think at the end of the day, we got to remember that we are dealing with human beings, both our clients and our adversaries, and treat them as such. One quick example, and this is from many moons ago, before even I was at Phillips Lytle. I was with the late great law firm of Mood and Sprague, and I had I was defending a railroad, and we had some depositions in London, Ontario, and then in Toronto for 5 days, and I was defending the railroad, and the plaintiff's attorney, I won't name him or her, it was him, but we didn't have a judge or referee, and it was getting very hot, I mean really hot, and I'm not a real excitable person, but I was as excited as I think I ever get, and I wanted to kill him. And, but about 3 days into it, we're in Toronto, and we get done with another day, and I just thought this person is just totally worthless. And we get done, and his son is also practicing with him, and so we're packing our bags, and he says to me, well, we had one more day, so we're staying overnight again. He said, well, what are you doing for dinner? And I said, I don't know. And he said, well, come on, join us. I said, okay. And it was like a switch got thrown. He was suddenly just the most gracious person. We laughed, we joked. We had a great time, and the next day we went back to beating each other up. I won't say it all had a happy ending. I probably lost the case too. But I did, for a brief moment at least, realize that, hey, this is a human being on the other side. And it's something that 20 plus years after the fact, I haven't forgotten it.
Judge Pickett?
I can't add much. You know what I find interesting, though? Are matrimonial lawyers. Because when we talk about having to get along, if you think about criminal law, you have the plaintiff, people's bar, and you have a defense bar. On the civil side, in personal injury, products liability, medical malpractice, you have a plaintiff's bar, and you have a defense bar. In matrimonial, you don't. And these lawyers who practice this way can be the plaintiff on one case, the defendant on another, the guardian for the children on a third, and have the ability to resolve these cases. And once again, thinking about the good ones. To get these done and get them done in the best interests of their clients and bring the case to conclusion very, very well. And I think they're an interesting group in that sense, because it's more like what law used to be, where you might be on one side or the other more often than not. And that doesn't happen a whole lot. And I keep focusing on as a judge and looking at things from the court's point of view. And quite often it's the court that gets in the way, and I always regret that. I think that if we let lawyers do what lawyers can do and should do, the whole justice system would be a lot better, because as John and Jerry point out, I mean, the good lawyers get this done, and all we're supposed to be is the detached, disinterested magistrate that finally determines these things. And if we do our job, it makes it a whole lot better for all of you.
Mike?
What struck me about this was, of all the vignettes, this seemed to be at least a partial misapplication of some principles to the practice of law, particularly in litigation. With malice towards none, absolutely right. There should never be a malicious word said in litigation, and that would be the ideal that we should all strive for. Charity for all, not a chance. Litigation is a war, it's a battle, it can be done civilly, but our obligation is to do the best we possibly can for our clients, and that does not mean that you have to be uncivil at any time, but you certainly do not have to be charitable in the sense that you do anything to make yourself more popular at the expense of your client. And I think we need to have that balance in this program, because these programs often focus mostly on this on the side, or on the issue of how do we be more civil, and I think it should focus on that. But at the same time, particularly to you young lawyers, never lose that zest for representing your client as vigorously as you can. And going back to something in, I think, the first or second vignette, that was said about Lincoln, that he could be your worst enemy if you took up a cause that was unjust to his client. So I think that's the balance that we strive for.
Can I, Greg, just jump
Sure.
in to add one?
Your lord.
To add on to what Mike said, and I do agree. I mean, this is, and I apologize to the non-litigators for focusing on litigation, but I think a lot of the same principles arise in the negotiated area as well. But yeah, you've got an obligation to your client and to your client's position, but one concrete example I can give you of how you can balance that with basic human decency is if your opponent calls and asks for, say, an extension of time to file an answer. Now, there may be a case where you have a real good reason why you can't grant that extension, and in that case, I think you just tell your adversary, I would, but I can't, and here's why. But if, but failing that, and that will be the rare case, if your client says, no, we can't give any ground here, I think what you got to say to them is, look, if we don't give it, they will go to the judge, and the judge will want to know why we didn't give it if there's no good reason, and that will impact the judge's view of us and our, judges are human beings too, so we try to be, just take each issue as it arises, but we do get an impression of lawyers and litigants and their case. So I think that's the way to sell it to your clients. If you don't want to do it for the sake of decency, do it for the sake of advancing our cause long term.
Our next vignette, brevity and clarity.
Fourscore and 7 years ago, our fathers brought forth on this continent a new nation, conceived in liberty and dedicated to the proposition that all men are created equal. Now we are engaged in a great civil war, testing whether that nation or any nation so conceived and so dedicated can long endure. We are met on a great battlefield of that war. We have come to dedicate a portion of that field as a final resting place for those who here gave their lives that that nation might live. It is altogether fitting and proper that we should do this. But in a larger sense, we cannot dedicate, we cannot consecrate, we cannot hallow this ground. The brave men, living and dead, who struggled here have consecrated it, far above our poor power to add or detract. The world will little note nor long remember what we say here, but it can never forget what they did here. It is for us, the living rather, to be dedicated here to the unfinished work which they who fought here have thus far so nobly advanced. It is rather for us to be here dedicated to the great task remaining before us, that from these honored dead we take increased devotion to that cause for which they gave the last full measure of devotion, that we here highly resolve that these dead shall not have died in vain, that this nation, under God, shall have a new birth of freedom, and that government of the people, by the people, for the people, shall not perish from the earth.
Abraham Lincoln's most famous speech, the Gettysburg Address, is a model of brevity and clarity. It consists of 272 words and took about 3 minutes to deliver. The conciseness of his language is even more striking when compared to the 2-hour oration given on the same occasion by noted statesman Edward Everett. We should not assume, however, that because the speech is so brief, Lincoln did not spend much time composing it. Lincoln knew what all good writers know. Brevity and clarity in communication require time and effort. The old story about Lincoln jotting the speech on the back of an envelope en route to Gettysburg is a myth. In fact, he spent several days in preparation, and he went through many drafts. According to his law partner, William Herndon, Lincoln was a slow writer, reflective, and not spontaneous. He liked to sort out his points and tighten his logic and phrasing. The final product of the Gettysburg Address plainly reflects this care and craftsmanship. Every word counts, but the address is not merely short and simple. It shows a flexibility of structure, a rhythmic pacing, and a variation in length of words and phrases and clauses and sentences that make these sentences move naturally despite their density and scope. Of course, we do not revere the Gettysburg Address for its style alone. Indeed, it demonstrates one of the most important but difficult attributes of legal writing. The address is profoundly creative in its legal argument. Lincoln asserts that the nation was conceived in liberty and dedicated to the proposition that all men are created equal. In reality, the Constitution did not refer to equality, and it expressly tolerated slavery. In proclaiming the Declaration of Independence as the true founding document, however, Lincoln recast the argument and emphasized a different precedent. His creativity helped to bring about change in the fundamental law of the land. Within 5 years of the Gettysburg Address, the 13th and 14th Amendments had abolished slavery and guaranteed equal protection of the laws to all.
Mr. Job well done. Mike, you hear that Gettysburg Address, what's your feeling? I mean, what's your visceral here?
Clearly the greatest speech ever written, in my opinion. And there's 2 points that I take away from that as it relates to the practice of law. Brevity, as I always tell the people who work with me, have the courage to be brief. And there's the old story about someone went up to a judge and said, "Judge Piggott, why did you write such a long opinion?" And he said, "Because I didn't have time to write a short one." And there's a lot of truth to that. It takes a lot more work and time and effort to write briefly than it does to just put down on a piece of paper your stream of consciousness. And I can tell you that of the hundreds, probably thousands of briefs I read when I was a law clerk to Judge Jason at the Court of Appeals, the ones I still remember, not specifically, but in general, were the ones that were short, they were clear, and they were to the point. So brevity almost always brings clarity and persuasiveness. The other point in that vignette, to go back again, is Lincoln's creativity and his ability to appeal to the best that's in all of us. He did not refer to the Constitution, he referred to the equality referenced in the Declaration of Independence, and in doing so, he reset the stage, recast the argument, and it's now something for the ages. So think of that when you're writing your briefs, to be clear, to be creative, and to appeal to the best in all of us. Again, as I said before, that's more likely to carry the day for you.
Judge Piggott?
Appellate practice, wow. I can say a couple things that are very pedestrian, but I think just can be helpful. People, when they write their briefs, don't have, I don't have the courage to judge the 5 that are going to see me, that I'm going to see in Rochester, or the 7 in Albany, or even the 1 that I'm going to be talking to in Buffalo, if that's the case. And you don't know. You don't know how smart they are. You don't know how lazy they are or not. You don't know, the mood they're in or anything else. And it's very scary to try to put in as concise form as you think it ought to be, something that ultimately could find its way up the ladder, so that you're writing for Judge Hardbottom here in Erie County, and you win or lose, and now you find yourself in Rochester as an appellant or a respondent talking to 5 judges, and all you've got is what you wrote in the beginning. So brevity's great, and I hope people do it. I'll tell you where they miss, where people miss all the time. And that's what I'll call clarity. Because when you write, you'll write summary judgments, a drastic remedy, the trial on papers. We know all that. That's what we do every single day. So telling us that, while sometimes it may be helpful, makes you less brief and says things that we already know. What we don't know is anything about your client. And when people come, we had a case a couple of years ago involving one call. You know, that's a organization. You know, you call before you dig. That thing. Well, it's quite an organization. We didn't know it in the Court of Appeals, but there was a small water district that said we shouldn't have to be paying the one-call fees because we're not a municipality as defined under the general municipal law. And so that argument went on, but on oral argument, it finally came out. Somebody said to the lawyer representing the one call, says, "Well, what are we talking about here? We're talking nickels and dimes." She said, "We're a $77 million, I mean, it was huge. They have this massive organization that does this, that's funded by these fees, that then is permitted or permits these diggings to be done without blowing up towns and fracturing water mains." We didn't have a clue. It wasn't in the briefs. It wasn't in the record. None of that was there. So the clarity that we needed was talking about the client. It's not the clarity that 3211 or 3212 is this or that. And that's what people miss. It's something you just keep in the back of your mind the next time you're putting something together, because you can make it briefer by not trying to tell us what we already know, and clearer by telling us those things that we don't.
Judge McCarthy.
If you'll indulge me to just vent a little bit about my personal favorites, what I love is to see a brief where they begin and say, plaintiff, paren, quote, plaintiff, unquote. Has sued defendant, paren, quote, defendant, unquote. It drives me crazy because I think, don't they think I get it? But I know that happens quite frequently. The other personal bugaboo of mine is the phrase, the instant case. What the hell is the instant case? And I think we all need, we all need to ask ourselves, would we use this phrase when talking to somebody else about some non-legal topic? And if we wouldn't, think twice about including it. There are some type of concepts that only arise in the legal arena, but I think we all, lawyers and judges, could do a much better job of being concise. And this is one area in which I think the non-litigators can also focus, because if you draft a concise agreement, then God forbid there may not be litigation over it, and then we're going to be out of work. But the other thing I would suggest is that whatever you write, put it away for a couple days before you file it. I know we all got time pressures, but I think back to my days in college when I had a term paper, and the plan was a month before it was due, I'd have my little index cards, and then 2 weeks before it was due, I'd have my first draft. And of course, it was 3:30 in the morning of the day it was due, and I'm typing away and slugging down coffee, and it's sounding great. But then if you go back and reread it a few days later, you realize I could have done a much better job of tightening it up. And again, I think judges are among the worst offenders. So we've all got to do a better job of saying what you mean, saying it once, and then let that stand or fall on its merits.
John?
Just a couple of points tying this in with the Cincinnati case ways back. Those of us that practiced out here, we can relate to Abraham Lincoln a little bit in that situation with the big law firms that came in and asked him to act as local counsel. and then kind of treated him very poorly. That's a mistake on the part of big law firms. You read the same law cases that the big law firms read. You have the same statutes to interpret. You meet with the clients. You argue the case in trial. And when it comes to time to write that brief for the appellate division or the Court of Appeals, you know more about your case than anybody else does at that particular point in time. I would always tell that to younger attorneys I worked with, Paul Andrews, Kurt Gustafson, and some others over the years. And I mean that. You know as much about that case as anybody else at that particular point in time. Brevity is important. I'm going to use a line that Judge Scalia has been quoted as stated. I thought one of the other judges might, but since they didn't. Judge Scalia at one point said, "I never read a brief. Upon completion, put it down and said, 'Gee, I wish it had been longer.'"
With that, Lincoln on professionalism.
I met with Mr. Lincoln in his office on April 15th, 1845. I hastened to his office in an attempt to be on time. I was anxious to hear Mr. Lincoln's opinions about the defense of my case and was hopeful that he had better news for me that day than he had previously shared. I explained that I'd given serious thought to finding another lawyer. Mr. Lincoln assured me that I was within my rights to do so, and that he could recommend a colleague who would take my case. I must say that surprised me. I thought he was trying to dismiss me as a dim-witted woman with little sense. I stood to my feet, but as I was about to discharge Mr. Lincoln, he spoke. He warned that any other lawyer of honest repute would give me the same advice he offered, to settle the matter immediately. I sat down in my chair in complete surprise. I was referred to Mr. Lincoln by a good friend of my late husband. When my husband had died some years ago, he left me and my 3 children with a small general store and little else to support ourselves. The thriving town in which we lived provided us with a strong sense of security, and I was afraid that I would lose that security if I had to pay one of my customers $500 for stepping and falling through a floorboard in the store. I had no relatives who could help me pay this money, and I knew that the bank would not loan the money to help me settle this matter. Mr. Lincoln patiently explained to me what my liability was and described how the court would decide if I should pay the injured customer for his medical bills and other damages. He also told me that any competent lawyer would provide a client with all of the information, whether good or bad, to equip the client to make the most informed decision possible. And that's what he aimed to do. Mr. Lincoln explained that our justice system is based on fairness and honesty. That was how he practiced law. He described how the law favored protecting visitors to a store and how I, as the store owner, had a duty to maintain the store premises so that a customer in the store would not be hurt by some obvious harm. He then told me that he had met with the town carpenter, with whom I had conferred only weeks before the incident about replacing several rotten floorboards in the store. I understood his explanations of how the facts applied to the law. I asked him if there were some other way to address this problem besides paying $500 demanded by the customer. Both he and the plaintiff's lawyer, whom Mr. Lincoln obviously respected, knew that the demand for the case was high, and that the damage to me and my children by being bankrupted and closing the store would not serve well the town or any other cause. As Mr. Lincoln described it, it simply became a matter of what fair amount would make the plaintiff whole. To that end, Mr. Lincoln and the plaintiff's lawyer agreed that the amount was closer to $250 than $500. That was a good start to settling this case for all concerned, according to Mr. Lincoln. He soon made me see my fault in not protecting my customers from injury by not warning of the rotten floor when I knew of the potential harm and not fixing it sooner. By the end of the meeting, Mr. Lincoln and I had written out a plan by which I could take over payments of the plaintiff's medical costs and provide him credit in my store for the remaining settlement amount. This arrangement I could live with. My family's livelihood was secure, and the plaintiff was made whole. Mr. Lincoln, obviously pleased, said that the balance of justice was maintained for the good of all.
This segment deals with candor to the client. And let me start with you, John. You're
Well,
sensitive.
again, I would just note that the foresight here, this was before any rules of professional responsibility. The current code, I think the rule is 2.1. In representing a client, an attorney shall render candid advice. In so doing may refer to the law, as well as moral, economic, social, psychological, and political factors. Kind of taken aback by the foresight and the wisdom of Mr. Lincoln.
Judge McCarthy?
Well, I mentioned earlier the times where it may be necessary to have a hard talk with the client about a particular argument that may not be worth making, so I won't belabor that point. Obviously, everyone has a duty of candor toward their client. I think, and without getting off topic, I think hand in glove with that, and perhaps of equal importance, where I see complaints are not communicating with the client as frequently as you should. A lot of times, I see it in criminal cases, sometimes where the defendant will come in and say, I haven't spoken to my lawyer since the last time we were here. So you've got an obligation to keep your client informed of developments, good and bad, and that's about it.
Judge Pickett?
I don't think I could add to that. I think that's a good summary there, Judge.
Mike?
I think there's two parts to this issue. When you're giving your client advice, one is objective and one is subjective. The objective piece is quite simply to tell your client the good, the bad, and the ugly, so that he or she or it can make a fair and informed evaluation of how they want to proceed. There's no compromise on that your client deserves that, and you owe that to your client. The subjective piece of it requires you to know your client. In order to give your client advice on how to proceed, you have to know what that client is made of. For example, we have some clients that are no-pay clients. Millions for defense, not one penny for tribute. We have other clients that make their decisions based on economics. How much will it cost to defend this case versus what is the downside at the end? Can we settle it now even though we don't have liability? Because in the end, we'll be better off economically. So in order to be candid with your client about your advice, you have to know how they're built, where they're coming from, and how they actually make their decisions. And that sometimes is difficult, particularly if you have a client, a new client, or a client where you only have one matter for them. But that does not relieve you of the responsibility to know that client well so that the advice you can give them is accurate, useful, and candid.
Part 9, diligence.
Father, I've been thinking. I've decided to become a lawyer. I hope to be one as good as you. Ma says I'm a good thinker and writer. What do you think?
Robert, your ma's right. You've surely got the skills. But may I ask what might be your purpose? Why do you want to go to lawyering?
Well, to make you proud, Father, is foremost. And you being a lawyer has turned out quite well for all of us. And all the leading men of your cabinet are lawyers. Didn't de Tocqueville say that in America, the authority entrusted to the legal profession is unparalleled?
Well, son, as a young man, I too marveled at the confidence conferred upon lawyers by the people. And this in spite of the few seedy characters that stir up litigation and skin their clients with large fees.
But do you think I have what it takes, Father? How should I prepare?
Maybe you've prepared more than you know already. Take your reputation for integrity, honesty, and punctuality, and simply extend it to your quest to become a lawyer. Your reputation as a lawyer will be based in good measure on your honesty and forthrightness. Oh, the law will test you, but you must carry your honesty and courtesy to each judge and opposing lawyer alike. Some people believe that lawyers are less than honest, even those who trust lawyers with high public office. But you must resolve to be honest at all events. I've often said, if you cannot be an honest lawyer, resolve to be honest without being a lawyer. Choose some other occupation.
But Father, will I be able to earn money as a lawyer and always at all times be honest? Do clients pay for their lawyers to be honest?
Well, I've found it is the client who looks to the lawyer, but is the judge and public who looks at the lawyer. Honesty builds reputation. A good reputation, in turn, attracts clients. I became very careful not to accept money from clients I knew to be on the wrong side of justice. And I always wanted to bring honesty's sister, forthrightness, into the courtroom.
Father, you were always so long away at the office and on the circuit. Just how hard is the work of a lawyer? Will I have to live my life in the office and in the courtrooms?
I hope not, dear son. Yes, I'm afraid that the law kept me too long away from Mother. But diligence in preparation in all cases served me well. Many lawyers saw themselves as able to sway a jury with oratory, but with only a dash of preparation. But if anyone, upon his rare powers of speaking, could claim exemption from the hard work of the law, his case is a failure in advance. The leading rule for the lawyer is diligence. Never leave for tomorrow what can be done today. Well, after the war is over, we shall have more time together.
Diligence, diligence. Judge Piggott, what'd that vignette mean to you?
Something I was very poor at. It takes me back to my Blue Jay theory, which is that you can waste an awful lot of time reinventing the wheel in the practice of law. And today, with the miracle of computers and word processing and everything else, you can avoid it. And I think the more we do as lawyers in avoiding the drudgery and get to the real nub of the case, the better off we are. It's something that's easy to talk about, difficult to do. And one of the things that I leave up in the air, because we talk about all these great things that good lawyers do, dealing with the other side is just impossible sometimes. I mean, the bad lawyer, the lazy lawyer, the slow lawyer, the dishonest lawyer. And I frankly don't know how you handle all of those except do the best you can under the circumstances. And focusing again, as I have for the last 15 years as a judge, it is just refreshing when someone is diligent, is there, better to be an hour early than a minute late, as they say, and moves their case along. In the notes here, there was one where a judge wrote about how efficient this lawyer was in concluding a case within 10.5 months, I think. And that it really is inspiring if you can ever get that done. The problem, of course, is dragging your opponent, whichever side they are, to the same standard. But it's certainly something to aspire to.
Judge McCarthy.
Yeah, diligence goes without saying. I guess one difficulty that I'd like to touch on that I know is probably becoming more prevalent today than before are billing pressures. And I was just reading the other day, I can't recall where, but about some clients who will not pay their lawyers for doing legal research. I guess on the assumption that you learned it all in law school, but you got to be very careful to spell out the relationship in a way that you feel that you can diligently and adequately represent your client, because you can be sure they may not want to pay you for the research, but if they get the wrong result, it's all going to be on you. So I think you maybe need to, not maybe, you do need to set those ground rules in advance. Clients often will ask for a budget, and you got to be as honest as you can in giving that to them, and it may be news they don't want to hear because they're not prepared for that, in which case maybe you ought to be talking, again, if we're dealing with a litigated matter, you ought to be talking about approaching settlement sooner rather than later. But I think you need to spell out with your client what you intend to do to progress the matter, and that they will be expected to pay you for that. You can make a lot of decisions that are judgment calls, such as how many depositions do you want to do, for example. Maybe the client doesn't want to do a lot, fine, but you got to spell out that relationship on the front end so that you will be as diligent as they will allow you to be. And if you really feel that they're cutting your legs out from under you, then I think you need to decline that representation.
John?
Just a couple of comments. The sad part about that video was when he said to his son, after the war, maybe we'll have more time together. And of course, after the war, Lincoln had died on April 15th of 1865. He did not get that additional time with his son. Every attorney has the problem of balancing work and family. And that problem existed 50 years ago. It exists today. I personally think it's harder for the younger generation today than when I started out. Computers, emails, texting, it's 24/7 for some of you. I almost think those of us that do practice down here in the rural areas, maybe we've got a little bit of an advantage that way. I know I've got a son and son-in-law who practice with big firms in New York. It's tough today. You have to, however, make some time for yourself. You just have to, whether it's 15 minutes each morning or once in a while take some time off. But if you don't, you're going to burn out. There's a book out that I think every attorney should read. It just came out the past few months. It's by a Michael Trotter called Declining Prospects. It's talking about the problems that the legal profession is facing, not so much those of us in the smaller rural firms, but the big firms. Dewey and LaBeouf, for example, the gigantic firm in New York that went bankrupt on May 28th of this year. 1,410 attorneys. Competition, lateral movements, technology, contributions due for pensions to the partners, the amount of money the partners were making. It's a disturbing book. Should be read by all of you. You know anybody in law school, I suggest they read it, but more importantly, you know anybody thinking about law school, maybe they should read it. I would note that earlier today, Mary Ann made reference to the TV show Jeopardy, I believe. If you remember a few weeks back, a few months back, maybe a couple of years back, they were having the contestants challenge a computer by the name of Watson. In this book, Declining Prospects, IBM right now is planning to have computers be able to take the work of a lot of associates, young associates, accumulate thousands, if not hundreds of thousands of pages of documents, be able to answer questions and come up with those documents in seconds. The technology that we have seen advance so much the past 20 years is not stopping. It's continuing to go forward. And so what Lincoln and his son dealt with back in the 1860s, you all still have to deal with, and you have to deal with it personally. How do you create some sort of balance between work and your own personal life?
Mike, how have you done that?
Very poorly, unfortunately, but diligence is the sine qua non of being a successful lawyer and doing for your clients what they deserve and what you're obligated to provide. That is what makes the law truly a jealous mistress. And it's important, I agree with John, particularly for the younger lawyers, to make sure that you start now to strike a balance between your personal and professional lives. Because if you don't, they will both suffer, and you will cease to be diligent for your clients, and your personal life will turn into something that you don't want it to be. And waiting for tomorrow, which is promised for no one, is never a good idea, as Robert Lincoln sadly learned. So going back to what Judge Pigott said, get to the point. The practice of law is incredibly demanding and getting more so now. There are many, many more distractions, and if you practice efficiently, civilly, and eliminate as much of the nonsense out of your practice as you can, it's going to make it easier for you to strike that balance that's so important.
We're drawing closure to an incredible 4 hours here, and I've given the final instructions from Mary Parsons. And she gave them to me, and as I listened to her, I said, but why? And she said, Greg, listen very carefully to what I said, because it's your guy, Justice Robert H. Jackson, who said, I, Mary Parsons, am final, not because I am infallible, but I am infallible because I am now final. So with those instructions, here's our conclusion. We're going to view this final vignette to conclude this program. And following this vignette, the audience members may go directly downstairs for lunch, and we'll be conducting the interview with J.U. Kalkrick. Please remember to submit your CLE attendance and evaluation forms on your way out. Since we're going to conclude at the end of the vignette, let me thank in advance our panelists, Judge Jerry McCarthy, Judge Eugene Pigott, John Plum, and Judge Michael Powers, who together with the previous speakers, Betsy Constantine, Mike Engdahl, and Marianne Sacamanda-Friedman, have provided us 4 hours of an incredible continuing legal education, probably one of the best, if not the best, we've ever had here. So please give them a round. And just a quick housekeeping matter for Michael and Betsy, if she is still here, and Marianne. We're going to have a photo op up here right after that, so please join us there. With that, we'll dim the lights and watch the final vignette.
Our goals for Lincoln on professionalism were twofold. First, we endeavored to impart the ideals of professionalism in a noble calling and to hold out Abraham Lincoln as the embodiment of these ideals. In doing so, we hoped at the same time to meet our second objective, to inspire the members of the bar to commit to these standards. Toward these ends, we reaffirm the principles that Lincoln's example compels.
Practice honesty and maintain the highest integrity with your colleagues, adversaries, clients, the general public, and the courts. As Honest Abe said, if you cannot be an honest lawyer, resolve to be honest without being a lawyer. Choose some other profession.
Exhibit dignity and civility to your adversaries and colleagues. Lincoln's experience with Edwin Stanton demonstrates that another's discourtesy and incivility should not be taken as a license to respond in kind.
Uphold allegiance to the values of honesty, forthrightness, and integrity, and jealously guard your reputation for the same. Lincoln viewed these values as more important than any one client, and believed that one's reputation for honesty attracted clients.
Recognize that your adversary is not your enemy and need not be vanquished at all costs. Lincoln understood that even in conflict, what opposing parties have in common is often more important than their dispute. Where adversaries focus on commonalities rather than differences, they foster a more cooperative and collaborative relationship. Unproductive conflict distracts from the genuine issues and unnecessarily increases litigation costs.
Practice clarity and conciseness in your communications. Lincoln's Gettysburg Address, arguably the most famous speech in American history, consisted of only 272 words and was delivered in approximately 3 minutes. The importance of this address more than justified a longer speech, yet Lincoln appreciated that brevity and conciseness facilitated the clarity the speech required. We can all benefit from Lincoln's wisdom.
Provide your client with all the information she or he needs, particularly when that advice may be unwelcome. Lincoln believed that competent attorneys must provide information sufficient to equip their clients to make the most informed decision possible. This is especially crucial when an attorney is compelled to counsel settlement rather than litigation.
While we cannot expect to be confused for Lincoln, there is much we can learn from him and the example he set. In the end, the honesty, integrity, and clarity of thought with which Lincoln practiced law and later governed our nation are not the exclusive traits of perhaps our nation's greatest president, but the minimum standards we as attorneys owe to the communities we serve.
With that, we stand adjourned. Thank you, everyone.